I heard you were an Orioles fan. Scott McGregor was just in Jamestown 2 nights ago.
Oh, I loved Scott McGregor.
Yeah.
He was one of my favorite players in that '79 year when they lost that 3-1 lead to Pittsburgh in the World Series. Scotty McGregor pitched Game 7, if I'm remembering.
That's right, man.
I thought it was a mortal luck because the Orioles were up 3-1 and they had Palmer, Flanagan, and McGregor pitching the next 3 games, and they managed to lose all 3.
I was at that 7th game in Memorial Stadium and listened to We Are Family all the way home, back to Jamestown. You were on the Hall of Philosophy today. I just want you to know that you're a continuum of history. Albion Tourget spoke there, and of course was one of the prosecutors, represented Plessy. Robert Jackson spoke there, and Thurgood Marshall spoke there, and now Michael Klarman.
That's a huge honor. Reminds me of, I live in a house that used to be owned by Julia Child, and before Julia Child, the first person who lived there was a famous philosopher who was brought to Harvard by William James, whose name I'm going to forget, and they wanted to do a plaque, and they wanted to know if we'd put a plaque on our house, you know, Julia Child and Josiah Royce is his name, that they lived here. And I thought, well, I'm going to hold out for Josiah Royce, Julia Child, and Michael Klarman.
the book that brought you...
Who doesn't belong in this list of names, yeah.
The book that brought you so much prominence, Mike, and I'm just glad you're here, is Brown versus Board of Education, Civil Rights Movement, which of course was the bridge edition of the Jim Crow to Civil Rights book, the Bancroft Award and everything else. And you explain often how you kind of got into that particular arena of interest. I guess suppose, here's right to the nut of it, Robert Jackson, we're part of the Robert Jackson Center in Jamestown, New York. Robert Jackson, a guy who was born here, bred here in Jamestown, New York. And as we learned when we studied during the 50th anniversary of Brown versus Board, kind of involved in a kind of a complex way with the Brown decision. What's your sense of his involvement, Mike, as you did all of this extensive work on the project?
I love Robert Jackson. He's my favorite justice. I always tell my students this, partly because he's such a terrific stylist, but also because he's such an interesting thinker. So his opinions in Korematsu and Steel Seizure, and then his draft concurring opinion in Brown, which most people don't know about, but I give to my students, is just such an interesting document. So I think Jackson and Frankfurter both have a real dilemma in Brown, because there's no doubt that they're committed to racial equality. Robert Jackson writes this famous letter to Charles Fairman in 1950. Those of us who served in Germany, we don't have any doubts about what the ultimate logic of racial segregation is. It's the Nazi Holocaust, so we don't have any truck with racial segregation. But he's committed professionally to the idea that judges are supposed to separate their personal views from their legal interpretations. And he believes, you know, he says this at conference, and it's such a powerful statement. He starts his conference statement in Brown saying, there's nothing in the text that says it's unconstitutional. There's nothing in the original understanding. There's nothing in the precedents. And so he's got this conflict. Here's something that's not just wrong, but it's Hitler's creed. That's how Black refers to it at conference. But he's also committed to the idea that judges don't let their personal views infiltrate their legal interpretations. And I think he has to wrestle with this. And he has this additional problem, which is he's kind of a doubter about the efficacy of courts trying to impose their will on public opinion. So he's not really sure that it's going to be very effective for the Supreme Court to do something that's, you know, perhaps so out of step with what the white South believes. So I think he's pretty conflicted.
How does he resolve that?
Well, you know, I've always thought that I don't know what the evidence is for this. I'm not making this up, but I've seen somebody talk about this, that Robert Jackson might have been hatching an idea to basically, you know, threaten the South and say, we're not going to strike down segregation, but we're going to give you a certain amount of time, and if you don't make separate equal, then we're not going to have any choice in the matter. And I haven't found any documentation of that, but I know I've read some secondary source speculating, and I don't think that's a crazy position to think Jackson might have been inclined to take. I think, a lot of modern liberals have trouble with that because it doesn't sound like it's firmly committed to integration, but the NAACP was taking a position that was not necessarily the view of everyone in the black community. There were lots of African Americans who thought it made sense to focus on equalization, that they didn't need integration, that they had schools they were proud of, and what they needed was decent funding. Robert Jackson talks about that in his draft concurring opinion. He says, you're not doing any great favor to black people to put them in white schools where the white teachers don't want them and the white students don't want them, and they're likely to be behind on grade level because their own schools have been scandalously underfunded. So I kind of think that's an idea Robert Jackson might have had some sympathy for, but I haven't actually seen any documents talking about that. I've just seen an occasional sort of hint that maybe that's something he had in mind.
Brown versus Board 2, it died prior to hearing and learning a decision. How would he have come down on Brown 2?
They were already, Brown 2 was resolved by the time they resolved Brown 1 because there was a bargain in Brown 1. The Justice Department had said to the court, basically, you may think your only choices are, leave Plessy in place or strike down segregation, but you actually got a third intermediate option, which is strike this down, but give the South a gradual, relaxed period of transition. And in the conference notes in Brown, several justices are already talking about that. They're already saying, I could vote to strike this down as long as we give time. And given that they thought unanimity was critical, the fact that they'd already essentially made a deal among themselves that they would strike it down but not do anything too rash, I think the outcome in Brown 2 was pretty much predestined by the time they decided Brown 1, and even by the time they first discussed it at conference, which is way back in December '52. Jackson did say some things that I think that are not quite consistent with what the court did in Brown 2. I mean, Jackson said he wouldn't be party to something that he saw as being so disingenuous, that he felt like he didn't want to be party to something that left the district court judges hanging in the wind, and that's exactly what the court did. So, Jackson might have been prepared to accept something that was gradual, but he might have wanted something more specific, less vague, less delegating of the issue to lower court judges who then had no political cover. I mean, the justices were deeply conflicted about what to do because on the one hand, they knew that if they just ducked it and sent it back to the district courts, they were giving them no protection at all, and the district courts are the ones who are going to live with this. They're the ones who are going to have to explain to their friends and neighbors why they're making them give up a century's worth of tradition, and they're going to make their lives miserable. On the other hand, the court didn't want to be really precise because the court seemed to agree that different circumstances would warrant different rates of desegregation. So what you could do in Richmond wasn't the same thing you could do in rural Mississippi. In Richmond, you might say desegregate tomorrow, and it might actually happen. In rural Mississippi, they're just going to laugh at you if you say that. So they never really worked out a good way of resolving that conflict, and I'm not sure there really was a good way of resolving it. I don't know that Jackson could have done any better, but Jackson did say something, but I don't remember exactly what it was. It was something to the effect of he would not be party to something that left them twisting in the wind in this way.
Going back outside of Brown, obviously we're going to focus a little bit on Jackson because we have a little bit of a time constraint. You talked about Korematsu, Barnett, Youngstown steel seizure. If you ever paused and wondered why there hasn't really been a good biography of him yet? Is it the complexity? Is it pragmatic justice?
I assume one day, hopefully soon, there will be a brilliant biography. He's deserving of it, and given his incredible career, right? I mean, you're not just talking about the time on the court, but you're talking about the lead prosecutor at Nuremberg, somebody who was so impressive within the New Deal that he was already being talked about as a possible presidential candidate in 1940. And he's such a great writer, you can just quote from him liberally. I mean, other than maybe Holmes, he's the greatest writer in the history of the court. There is going to be a biography. I don't know why there isn't one. I assume, if you only serve on the court for 13 years, you're disadvantaged in the long-term reputation, right? I mean, they do these polls of law professors and judges of the great justices, and the one strong predictor is all the people who served for 30 years tend to be regarded as great justices. So, Marshall was there 30 years, and Story was there 30 years, Black, Douglas, Harlan, field. I mean, it's not an accident that of the 10 people who are listed as the greatest justice in history, most of them were there more than 30 years, Holmes. So I think, Jackson died young, as did many of them in that era. That's an interesting point I mentioned to my students, that a bunch of them died in their late 50s, early 60s, and the late 40s and early 50s, right? I mean, Vinson, Murphy, Rutledge, Jackson were all, well under 65. Some of them were not yet 60. Nowadays, no justice quits or dies until they're 80, and it's just sort of a reflection on the difference in medical care, I think, or maybe how people take care of themselves or something. If Robert Jackson had lived what's today an ordinary life, he would have been on the court for 25 or 30 years, and then he'd get the attention that he deserves.
What's your favorite case of his?
I love, well, as I said, I give the students the draft concurring opinion in Brown, which I love because it's so sort of conflicted and tormented. So if you know the document I'm talking about, for 20 pages he goes on saying how there's no good legal argument against segregation. It doesn't violate the text, it doesn't violate the original understanding, it doesn't violate custom and tradition. And then the last 3 pages, it's almost like he just tries to concoct some rationale for going along with the decision, and he says, well, segregation's irrational. It used to be rational after slavery that you would segregate a race that was mostly illiterate, but given the extraordinary changes and accomplishments of African Americans, it's just not rational anymore. And his law clerk, another very impressive guy, E. Barrett Prettyman, says you can't possibly publish this because the country needs to believe that this is a matter of law, and if you tell them how conflicted you are and how unpersuaded you are by your own rationale, it's going to be a disaster. So I love that document, but it's not a published opinion, and we don't really know what he would have done with it had he not had the heart attack and been hospitalized. I think I really like the Korematsu dissent because it's so reflective on the problem of how law can set boundaries on what counts as legal. So what he basically is saying there is we're not going to acknowledge legally that this is permissible for the military to do, but the military maybe shouldn't pay attention to what the law is, right? There should be situations where the law does not necessarily apply. And that's an undeniable fact, right? I mean, that's Lincoln's position with habeas corpus. I mean, and that's the position that some people took with Obama and the debt ceiling. I mean, who cares whether the 14th Amendment says you can do this? You need to save the country, and that's the president's job. And that was Lincoln's position, right? I may be violating the habeas provision, but I'm not going to let the country and the Constitution fall apart. And that's kind of what Jackson's saying. He's saying, I'm not going to put my stamp of approval on this. I'm not going to tell you this is legal within the Constitution, but I'm also not going to act like the Constitution is the be-all and end-all, and it's the only thing that matters, and maybe you don't need to pay any attention to what I say. And you never get justices sort of self-reflectively talking about that sort of thing, and I just think that's really fascinating.
You're a pretty fascinating guy. And what I'm going to do is we're going to probably call this quits and go on, have some beer, and get some serious conversation.
Okay.
And we'll talk
That's great.
about baseball.
Okay. I also love the fact, I joke with this with my students as well, that Robert Jackson, the greatest writer since Holmes, never went to law school, or he had a year of night school at Albany, but maybe there's some correlation between his style and the fact that...
Or college.
Yeah,
He didn't go to college either.
I didn't know that.
Yeah, so he has no college education.
Right.
I didn't say that in your book either.
I didn't know that. No, that's extraordinary. Well, it's like Lincoln with one year of formal education, right? I mean, if you're a curious person who spends a lot of time reading and you're basically smart, that's just unbelievable what he accomplished.